Now, with news out of the United States that vaccines for children under 12 are now ready to begin, parents in Canada are asking when the shots will be available here and discussing whether they will or won't vaccinate their children. When parents disagree about issues like this, it can cause serious conflict, and the disagreements can even end up in court. For separated and divorced parents, the question can be an especially contentious one. The issue of childhood vaccination and parental disagreement has already been addressed by Canadian family law courts in the non-COVID context. And the COVID shot has been addressed by courts in a few cases with children over 12. What guidance can parents find on this topic? And how should parents think about having these conversations in a way that's collaborative and productive, even in a high conflict situation? Here today to talk about this issue are two family law experts, Sean Knights and Anthony Martin. We'll then be joined by stepfamily counselor Brittany Lynch. Now, Sean and Anthony, thank you both so much for joining me today. Anthony, let's start with you. There have already been cases on childhood vaccinations in the non-COVID context. What are the main principles about whether a child should be vaccinated against, say, measles, mumps, rubella if the parents disagree?
So the main question the court is going to ask is what's in the child's best interest? And I think it goes without saying that it's in the child's best interest to be vaccinated. In the pre-COVID era, case law on vaccination was pretty much unanimous. If there was ever a dispute before the court would typically land on the side of the parent who's seeking to have that child vaccinated.
Now, Sean, I know that this can sometimes come down to what's in the separation agreement, who has medical decision-making authority. But is what's in the separation agreement the last word? Or can a parent who doesn't have that decision-making authority challenge the decision of another parent?
I would say that a separation agreement is possibly and likely not the last word if a parent were to challenge it in court. Certainly here in Ontario, and likely it's similar across the country, the courts can disregard any provision of a domestic contract related to decision making if it is in the best interest of the child. So, even orders can be changed through a motion to change if it meets a certain test. So the courts are more and more in vaccine cases choosing to override separation agreements in favor of vaccinations, especially if the child is over 12. And so I would say that even if you have decision making with regards to medical decisions in the separation agreement, that's not something to gloat about.
Now, Anthony, there have already been some disputes about COVID vaccines for kids over 12. What are we seeing in the courts about this topic?
So the case law that's coming out now, the court's taking judicial notice that vaccines are beneficial for children. So I think it's any litigant who approaches the court to make an argument that the child shouldn't be vaccinated, they shouldn't receive the COVID-19 vaccination, it's really a losing battle. There was a case out of Saskatchewan in which a petitioner was relying upon some questionable medical evidence, making analogies with the Nuremberg Code and some bizarre arguments. It's just not going to fly. I think that as these cases come before the courts, they're all going to be decided in the same fashion.
Now, Sean, same question to you. What have you been seeing in these disputes, and what guidance might we expect for kids under 12 as that will ultimately head to the courts as well?
Well, I think as a child gets younger, the views and preferences of the child is going to be less and less important. However, one of the exceptions that we have seen is, for example, there was a case where a 13-year-old decided that they did not want to be vaccinated in a vaccine case, and the court didn't order them to be forced. That's probably going to be unlikely to happen. But courts should not have to be deciding whether vaccines are safe. When a parent exercises the courts will look at situations where a parent exercises their decision-making in such a fashion as to not follow routine medical advice or advice from public health guidelines that is universally given. The reasonableness of that parent's decision-making process is what's going to be looked at. So it's not good enough to print some stuff off the internet. You're going to need an actual medical expert or scientific expert to give evidence.